in this morning's incredibly important event, and we are very appreciative to people who've turned out as well, and to the people who are watching us and this event being streamed. I'm particularly appreciative from my MEP colleagues in the other political groups for coming. And I just want to start very briefly by restating the basic facts of the Assange case and why we're all here, because I think it is important to make use of the time that we have here. And before I do, I'd just like to acknowledge that with us as well is John Shipton, Julian's dad, who's on a tour of Europe, and John will be coming in from the floor later on. So, look, since April, basically 7 months ago now, the Australian journalist and publisher of WikiLeaks, Julian Assange, has been in Belmarsh high security prison in London. He's been charged by US prosecutors with 17 counts under the US Espionage Act of 1917. And I think critically you should be aware that the charges relate solely to the 2010 publication of US government documents on the war in Iraq and Afghanistan. That's the charge. The publication was undertaken by WikiLeaks, along with some of the world's most prestigious newspapers. I think it was widely recognised as a watershed moment in terms of investigative journalism. What happened really was the expose of information of a high public interest, including possible war crimes, government collusion with the private sector, diplomatic interference in other countries' affairs. Very, very serious. And there's a certain irony that we meet the day after International Day to End Impunity for Crimes Against Journalists, and actually it was the collateral murder video which in many ways captured the imagination so much, where WikiLeaks exposed the US Apache helicopter massacre of a crowd of civilians in Baghdad, including 2 Iraqi journalists who were murdered in that. And that was actually a turning point at that time. It really shocked the world, as it were. The publications included also prisoner files for Guantanamo Bay detention facility, where people were abducted illegally by the United States, and during the so-called War on Terror, taken by extraordinary rendition and held outside any reach of law. The publications included the Iraq and Afghanistan war diaries, which exposed the use of secret kill lists by special operations forces in Afghanistan, the Fragmentary Order 242 in Iraq, a secret order instructing US troops to ignore the evidence of the torture by Iraqi forces, crimes under the Geneva Convention. We also had the Cablegate revelations about the United States embassies interfering all around the world. In my own country, Ireland, we had the issue of the US involvement in using our airport in our neutral country on its way to wars in the Middle East. And stories like this were really replicated in every country around the world because of the information produced by WikiLeaks. That's the background to this. This is what we're talking about. These were, and probably still are, the most important public interest disclosures of our time. The seriousness of them and the impact they had on the consciousness of the citizens around the world means that this is revenge. This is payback now. And Julian Assange has been long sought for that. And this is what this is about. We know there was that the Obama administration began the criminal investigation into Assange and WikiLeaks in the early years, and that we know of a sealed indictment against him was already being rumoured in 2011. And it was because of this fear of extradition to the United States that he sought asylum in the Ecuadorian embassy in London in 2012. And after a full examination of his case, the Ecuadorian government granted him asylum. It wasn't believed. People thought it was a ruse to escape charges in Sweden, that they were only exaggerating. All that's gone now. We now know that that was true. It was in the background, and this was incredibly serious, and that's what we need to act on. There was a new government in Ecuador, obviously. The United States leaned on them in return for an IMF loan. They basically gave him up, and he was forcefully evicted from the embassy and surrendered to UK authorities. Within an hour, 1 hour, A US indictment was unsealed and he was formally charged by the US government in connection with his publications in 2010. 2 months later, 17 more charges, this time under the Espionage Act, were introduced. He faces a potential 175 years in prison. So as I said, this is the most important press freedom case of our generation. So before handing over to my colleagues, I just want to make 2 brief points. And again, to emphasise, he is being prosecuted solely for the publications of 2010, not anything else that happened in between. So whether you like him or you don't like him, or you believe the stories about the embassy and all that sort of stuff, it's actually entirely irrelevant. The facts are totally clear. There's no room for division. It's about the 2010 revelations, and this prosecution poses a very, very serious threat to civil liberties and fundamental rights. It isn't just about the life of one man, although his life is in danger, and Nils will give testimony regarding that. It's about a lot more of that. The implications are absolutely huge, and they go beyond Julian Assange's life. What we have here is an Australian journalist in the United Kingdom being prosecuted for espionage by the United States for journalism published in the UK. Unbelievable where this could possibly end up. It's about freedom of expression. It's about fundamental rights. This is a landmark case, and I think on behalf of all of us, I know our initiative in organising this event was to galvanise support across all of the groups, across civil society, across journalistic sectors, and I'm delighted that we do have a number of journalists here, digital rights activists and people who really see the serious implications. But we don't want you just here listening to what will be excellent speeches from our panel. We want you to use that information afterwards to change the discourse, because this is all about the extradition case now, which is commencing in February, and there's some very, very worrying aspects around that case which Nils will deal with. But I want to put it to you, if these charges were being prosecuted in 2011, the whole world would have been in uproar, because it would have followed the publication. Absolute uproar. So we have to go back in time and harness that anger and redouble our efforts. And we want to come out of this a grouping of MEPs from all of the political groups and people who are not affiliated to any political group. We want to have a gathering of MEPs who will attend the trial in February. We do know there are people going from other national parliaments and so on. The extradition is not inevitable. There's a political exemption in extradition law for journalists. Espionage prosecution of a journalist is by definition a political persecution, and that's the message we want to get out. So I really want to thank people for coming. I want to especially thank our panel, and I'll hand over to Fernando now, who has been given the task of introducing our first absolutely excellent speaker.
Thanks, Claire, and thanks for giving me the opportunity to take part in this event. Well, good morning, everybody. Thanks for coming. Journalism is not a crime is the introducing title of the event organized today by some members of the GUE NGL group of this Parliament, and that brings to my mind the fact that journalism and therefore freedom of speech are often the first victims in the case of open conflict. Journalism has been targeted all around the world by different parts involved in conflicts. In my own experience as a Basque political activist, I have witnessed the closing down of newspapers or radio stations and the use of torture by the Spanish police force against journalists of those media in the context of the Basque political conflict. But time goes on, and we are now living the era of the digitalization, and therefore our concern as progressive citizens of Europe lays on the side of user privacy, and particularly the use of private data extracted from our communications without any kind of permission. And that brings to us the opportunity of getting together journalism and the right of free speech, the right for free speech on the one hand, with data privacy and the misuse by governments and corporate business of technological innovation. Today we have with us David Greene, who is a senior staff attorney and civil liberties director of the Electronic Frontier Foundation, a leading non-profit organization defending civil liberties in the digital world. Founded in 1990, EFF champions user privacy, free expression, and innovation through impact litigation, policy analysis, grassroots activism, and technology development. Before joining EFF, David was for 12 years the executive director and lead staff counsel for First Amendment Project. And David also previously served as program director of the National Campaign for Freedom of Expression. He was a founding member with David Sobel and Shari Steele of the Internet Free Expression Alliance, and currently serves on the Northern California Society for Professional Journalists Freedom of Information Committee, the steering committee of the Free Expression Network, the governing committee of the EBA Forum on Communications Law, and on advisory boards for several arts and free speech organizations across the United States. David and the EFF have made a number of important interventions in the Assange case since the first indictment was handed down in April. He was consistently correct in predicting that the US government's case against Assange was much more expansive than initially appeared. It's the US case against Julian Assange and its wider implications that David is here to speak to us about. Mr. Greene.
Thank you, Fernanda. Thank you, Claire, and thank you all for having me here. I had no trouble accepting this invitation because to me this is a watershed moment in U.S. law, and certainly a watershed moment internationally as well. The Espionage Act, which Claire mentioned, Julian has been charged with. There are 18 counts against him. 17 of those are based on the Espionage Act, which is the U.S. spying law, which essentially makes it a crime to either obtain or disseminate national security or national defense information that is secret. And this law is 101 years old in the U.S. and it has never, up until this point, been directed at journalistic activity. And so the filing of these charges in May will really mark the very first time that this law has really been targeted towards what are very typical and well accepted journalistic and important journalistic practices, and that's really what I'm going to talk about. Today. And what I want to do is really sort of break down the charges against him, just to show how what Julian has been charged with are very standard journalistic practices. For example, one of the main points that the Department of Justice makes in the indictment is that in 2009, WikiLeaks published a most wanted leaks list, and specified that among many things leaks that they are looking for were two categories. One would be bulk databases, including a particular one called Intellipedia. Another would be military and intelligence documents pertaining to the Iraq and Afghanistan rules of engagement. And this forms a large basis of the indictment, but this is really just the journalistic practice of letting the public and potential sources know that you're interested in reporting on information and seeking out that information. And indeed, what the consistent strain we see throughout the indictment are really trying to make criminal standard acts such as encouraging a source to provide information, to indicating a public interest in receiving information. Indeed, the word "encourage" is used 9 times in the indictment, and each time it is used in a way that makes it seem that it's an improper act, that journalists shouldn't encourage sources, whether it's an identified source or even a potential source, to come out with information. One specific act that the U.S. in the indictment places a lot of emphasis on is a message that Assange sent to Chelsea Manning. Originally, what happened was that Chelsea Manning had obtained records and then brought those to WikiLeaks, and those were published, and then she had no more records, but was interested in getting more and was having trouble doing so because of the security measures. and said she didn't think she'd be able to get more. And the message that Julian sent was, "Curious eyes never run dry in my experience." And that's really it. And that single statement becomes the basis for many charges that he was encouraging and inducing, and even in one point soliciting, which is typically a term that's only used with respect to purchasing of information, soliciting her to break the law and to obtain records. But that really is a fairly, I think, benign statement of someone who really just wants more information and is encouraging someone to do it. And again, this is what we see consistently throughout the indictment: is what these charges are encouraging a source to, or saying, "I'm available. This is information I'm interested in," encouraging the source to provide that information, and then receiving that information for the purposes of publishing it, and then publishing that information on the internet. Those are the 4 acts which form the basis of 17 of the 18 counts in the indictment. I wanted to say a little bit about the Espionage Act. Again, it's 101 years old. It has not previously ever been used against journalistic practice, but importantly, it does not have any exception for journalistic practice written in it at all. In fact, there are very few exceptions in the Espionage Act, and there are no defenses in it as well. And so there's no defense to the Espionage Act that you were releasing the information as part of practicing journalism, or even that you were releasing the information or obtaining the information to serve some better public good. None of that matters in terms of the language of the Espionage Act itself. And so what we've seen for the 100+ years that the Espionage Act has been the law has really just been a consensus agreement between prosecutors and journalists that this law will not be applied to them. Every so often there's been talk by the U.S. Department of Justice that a certain journalistic act they believe would violate the Espionage Act, but there's never come to the point of actually indicting someone for practicing journalism. And this is important. And in some ways, I don't know that was done completely out of the U.S. government's largesse, or really just to avoid some type of constitutional challenge to the Espionage Act. Under U.S. law, it is very well established that you have a very, very strong, perhaps a near absolute right to publish truthful information pertaining to a matter of public interest, even if you know that your source has obtained that information illegally, as long as you, the journalist yourself, did not break the law to obtain the information. That's a very well established principle under U.S. law, and you could see how many applications, or perhaps all applications, of the Espionage Act to a journalist who merely received and then published information would run afoul of that. And so I think perhaps the U.S. was trying to avoid that type of conflict, having to in not charging journalists. Again, it's been 100 years, so their reasons have probably changed over time. And I do think the U.S. saw in Assange, and perhaps even the difference between how he was viewed politically in the U.S. between 2011 and 2019, an opportunity to really try and make this seem like an exceptional case, that maybe this was different, and this was not sort of opening the floodgates for further prosecution against journalists, but it's really not an exceptional case. And the few things that the U.S. tries to point out about Assange that they say are different are really actually not that much different. And so again, this is just the fact that the Espionage Act is being used for practices like this is really it is a landmark indictment under U.S. law for that reason, and has really troubling implications for the practice of journalism going forward. And the thing to understand is that the law is quite expansive, because he's being charged not just for direct violations of the Espionage Act, but under a general U.S. law that for just aiding and abetting the commission of any crime, which includes counseling and commanding or inducing someone to break the law. And here that really takes the form of counseling, commanding, or inducing a source to provide information to a journalist. And certainly what we don't want to see is that journalism becoming acceptable only if journalists are completely passive recipients of information, that they cannot have any type of relationship with the source other than merely receiving information unbidden. That it would not be a good thing for journalists. It would not be a good thing for democracies. Now, the legal thresholds to violating, although the Espionage Act is the language of it is very much in terms of threats to national defense and secret information. The legal thresholds are actually quite low. The U.S. regularly maintains, in many contexts, that the release of any classified material will cause an injury to the United States. So the Espionage Act does have a requirement that the disclosure must have been made with the knowledge that it will affect injury to the United States or an advantage to a foreign government. But that's really quite a low threshold. The U.S. maintains that happens with any type of release of classified information. And the U.S. government also has a practice of broadly over-classifying information as well. And so it's really not even enough to rely on information being classified as having some great significance. I want to focus for a bit on the specific charges that actually deal specifically with publication. There are three of the charges, specifically, these are, if you're following along with the complaint, these are counts 15, 16, and 17, deal specifically with publishing information on the internet. And these are as Claire said, the significant activity reports with respect to Afghanistan and Iraq, and the State Department cables. But it's really important to understand that WikiLeaks was not alone in publishing this information. This information was widely reported by news outlets around the world. Der Spiegel, The Guardian, New York Times, Al Jazeera, Le Monde. These were widely recognized as being important information regarding matters of public significance that the public had a right to know about. Where the U.S. tries to make this, the indictment tries to make this different, is by pointing out that what WikiLeaks did was that it disclosed the names of U.S. assets, and that the standard journalistic practice, perhaps, or at least what is implied, is that that a standard journalistic practice would not have been to do this. Now, regardless of how you feel about the decision to disclose the names of the U.S. assets, it's not a distinction that the law requires in any way at all. Sources of information, so within Iraq and Afghanistan. And but again, the Espionage Act does not require that. It does not require that act in order to have for someone to be charged. And we do note that there are examples where what would be considered more mainstream and established media will at times actually choose to disclose names of secret sources because they believe those identities are newsworthy. So there's certainly neither in the law nor in practice a bright line regarding the disclosure of the disclosures of secret sources. I want to spend just a little bit of time before I finish talking about the final count, which is not the Espionage Act count, but was actually what he was originally charged with, the violation of the Computer Fraud and Abuse Act. This is the anti-hacking law in the U.S., which broadly makes it a crime to gain unauthorized access to a computer system. We as EFF, as an organization, we have a lot of problems with the CFAA, as we call it. We think it is quite overbroad in its language and captures a lot of practices that endanger security research, for example, as well as gives great competitive advantages to operators. But what I think is important here is that the charges as laid out in the indictment on this count are actually very, very, very thin. They are completely made up of the fact there was an incident where Chelsea Manning was having trouble accessing a database. She told this to Assange. He said he might be able to help, and she sent him a part of a password hash, a partial hash. He then responds that he had no luck and asked if she could send more, and then that's it. And those communications, there's no evidence that he actually tried. It clearly was unsuccessful. Now, the law does include attempts to break into a system. But that's really it. What we see, what the U.S. does in the indictment to try to bolster that act is to list other acts that they think are quite threatening. But these things are actually quite routine, and indeed many of you sitting here might have done them yourselves. So in what is in the indictment called the manners and means of the conspiracy to hack into the U.S. system, the indictment notes that Manning and Assange used Jabber to communicate with each other. Again, I don't think that's criminal. That Assange concealed Manning as the source by removing users' names and deleting data logs before releasing information. Again, the idea of protecting the identity of a confidential source is a standard journalistic practice. Again, Assange encouraged Manning to provide records. And then lastly, they used a special folder on a cloud Dropbox to transmit classified records. So those are the acts that are used to try and bolster this very brief communication. So that's all I have for now. But I can't emphasize enough how what a change in the way this law has been used in the U.S. previously that this marks. Again, by filing these charges, as they did in May, it really broke a 100-year-old tradition, an understanding that this law would not be used against journalistic practices, and that should cause us all great concern.
Okay, thanks very much, David. That was immensely interesting and terrifying all at the same time. My job now is to introduce Professor Nils Melzer. Nils is the Human Rights Chair of the Geneva Academy of International Humanitarian Law and Human Rights. He's also Professor of International Law at the University of Glasgow. On the 1st of November 2016, he took up the function of UN Special Rapporteur on torture and other cruel, inhumane or degrading treatment or punishment. Professor Melzer has served for 12 years with the International Committee of the Red Cross as a legal advisor, delegate and deputy head of delegation in various zones of conflict and violence. On May 9th of this year, Professor Melzer visited Julian Assange at Belmarsh prison under his UN mandate, accompanied by 2 medical experts who conducted an assessment under the Istanbul guidelines, which are used to assess and document incidents of torture. The report, when it was released on the 31st of May, was uncompromising, stating that, and I quote, "In addition to physical ailments, Mr. Assange showed all symptoms typical for prolonged exposure to psychological torture, including extreme stress, chronic anxiety and intense psychological trauma. The evidence is overwhelming and clear. Mr. Assange has been deliberately exposed for a period of several years to progressive, severe forms of cruel, inhumane or degrading treatment or punishment, the cumulative effects of which can only be described as psychological torture. In the past month, Professor Melzer has warned that Assange's health is deteriorating and that his life is at risk. Nils Melzer will now give an account of his findings to date and will speak about how the arbitrary and openly cruel treatment of Julian Assange by the UK and US should be understood as a form of deterrence to journalists. Welcome, Nils.
Thank you. Thank you very much. This case obviously is so rich in facts and perspectives that it is easy to miss the forest for the trees. Therefore, in the beginning, let me zoom out a little bit and just look at the big picture. What are our democratic institutions for? What is the purpose? Why do we have them? And what is their proper functioning? About 200 years ago, a bit more, in this continent, in Europe, we were basically ruled by people who had absolute power, who could do whatever they pleased. About 200 years ago, we all decided we didn't like that. And we created states that were to be democracies governed by their people. And the rulers that governed these countries were subjected to the separation of powers. So we created an executive power that was to conduct the government's business every day. We created a parliament that was supposed to make the rules. And then we have the rule of law that governs even the governors. And then we have a judicial power that is supposed to watch over the proper functioning of these other powers, and also to control it and make sure that they actually function according to the rule of the law. And I'm not going to give you a history lecture, but I think it's very important to keep that in mind. This is what this is about. We have the separation powers, and in order for this to function, we need due process. Procedural rights have to be respected in court of individuals, so their human rights are being respected, so they can actually ensure the functioning of that system. And if those government branches start to collude by any chance, which they have a tendency to, because we're just human beings, we're not angels, we have a free press that can actually observe this and inform and empower the people. The press is not here to entertain us, they're here to inform us and to empower us. So this is the context, the environment within which this case is placed, in my view. And the proper perspective on this case is also to say, well, okay, if we're all focusing on Mr. Assange for a moment and the things he is being accused of, well, with WikiLeaks and disclosing secret state information, well, what is the need for secrecy in the first place? There may be a justification for confidentiality, but you need to justify that. It's not just because you would like something to be classified that it necessarily becomes something that should be kept from the people that are supposed to be the rulers of the country through democracy. So I think it is very important to keep all of this in mind. What Julian Assange is accused of in the US is basically investigative journalism, which we need. It's a systemic necessity for the sanity of democracy that we have investigative journalism. Should these information that have been disclosed have caused any harm? Well, we have a legal process that can go through which, WikiLeaks as an organization could be sued in court for proper damages. This has not really happened. Where it has happened in the US, it has been refused this year by a federal judge who said that this was protected by the First Amendment freedom of opinion. So if Mr. Assange has committed any offences in Sweden, well, then he obviously has to answer to that. But we need a procedure governed by the rule of law. For 9 years, there have been no charges against him in this regard. We just have a preliminary investigation, and Sweden has not been successful in establishing at least sufficient evidence to press charges against him. Even now that he's been detained in the UK for more than 6 months, they have not even questioned him there. So is that a credible proceeding? But if we look at what, on the other hand, is at stake, we have clear evidence for war crimes having been committed. We have clear evidence for torture having been committed on a large scale. We have clear evidence for corruption. We have clear evidence for a host of human rights violations. And there have been no prosecutions, no investigations by any of those states that scream so loudly about the rule of law in this case. What weighs more heavy for the sanity of democracy and the rule of law? War crimes, or someone being allegedly accused of having tried to help someone decode a password but not having succeeded and not having caused harm, and having published information about government misconduct, which is inherently in the public interest? I'm not saying there are not legitimate concerns with regard to the internet and harm that can be caused through the internet in all various domains, but let's discuss it. But what's happening here is different. Now, how do I come in? I'm the Special Rapporteur on Torture and Ill Treatment. I visited Mr. Assange in prison on the 9th of May, about a month after he has been arrested by the UK, after having been expelled and deprived of his asylum status by Ecuador without any due process of law. Speaking of due process again. I took with me, because I knew this was a very politicized case, two medical experts, a forensic expert and a psychiatrist who have worked with torture victims for decades. They know exactly what's the difference between symptoms that are caused by ill treatment and torture and what are symptoms that come from pre-existing conditions, medical conditions, people that pretend, or you have a violent arrest or whatever that could happen. So experts that can objectively distinguish that. We've ran an examination for 4 hours based on the Istanbul Protocol that is designed to evaluate torture victims, and the result was clear. He showed all the symptoms that are typical for persons that have been exposed to psychological torture for a prolonged period of time. It's something you cannot miss. I cannot go into all details for the medical confidentiality, but these are clear patterns of intense anxiety, of intense stress levels that have nothing to do with the ordinary stress and anxiety someone would have in prison that's facing a criminal proceeding. It's at an intensity level where a person no longer can relax for months or even years, and this can have severe, also physical consequences, and causes intense and progressively intense suffering. In his case, it was relatively easy to identify the causes for these symptoms with a high degree of certainty, because he had been isolated in a specific place for more than 6 years and exposed to just a small number of possible factors that could have caused severe symptoms like that. And I wrote letters to the UK, who have him in his custody, still do now, and the other states that were responsible for his conditions of life for the past years before my visit, and that was the US and Ecuador, obviously, and Sweden. I wrote official letters that expressed concerns in 3 regards. First, well, what has caused these symptoms? I asked these states to investigate their individual contributions to the extreme stress levels and anxiety levels that Mr. Assange has been exposed to. I asked them to explain why they didn't intervene in order to make his living conditions bearable. I asked them to explain the perceived due process violations in Sweden, in Ecuador, in the US and the UK, and I've asked them also to take urgent measures to relieve the pressure on him, because both medical experts told me that if the pressure is not alleviated soon, his state of health will deteriorate rapidly and to a dangerous level. 10 days later, he had to be transferred to the medical care division of the Belmarsh prison. So our predictions were correct. I told the prison authorities on the day of my visit about my assessment. I informed the British government. The British government did not feel it was necessary to even respond to my letter for 4 months. 5 months after my visit, on the 7th of October, I received a 1-page response saying we reject any allegations that Mr. Assange has been exposed to torture, and he's treated in accordance with English law. No offer of dialogue, no explanations whatsoever. And that's 5 months later. In the meantime, Mr. Assange has been detained in almost isolation. It's not solitary confinement in a strict term, but it's isolated from the population of the prison. He is in a single cell, reportedly. He is what I've been told is that whenever he passes through the prison corridors, they are cleared. He has no contact whatsoever with other detainees. I think that is extremely difficult on months on end. He is apparently surveilled in obviously very stressful conditions. And now if we come to due process, it's only in October, after being arrested in April, that he has received access to his legal documents. How is that possible, that you are the defendant in criminal proceedings, subject to an extradition proceeding to the US, where I am convinced he will not get a fair trial, but will be subject to a closed, secret show trial, and then eventually very likely disappear in a high-security facility for the rest of his life, in conditions that my mandate and my predecessor in the US for high-security detainees have repeatedly criticized as being inhumane and cruel and degrading. So how is it possible that in the UK a person like this does not get access to his legal documents, that he is asked to respond to an indictment he has not been able to read? To me, this is outlandish. This is not worth of democracy. This increases stress levels, and we may not personally be able to relate to that. But these types of, if you're exposed to a constant environment of arbitrariness, where you can't trust the authorities you're exposed to, where you don't know what their next step will be, where you don't know what you can say in court, because in any case, any legal remedy you take has no prospect of success, because the whole system is biased against you, where judges that have a documented conflict of interest are allowed to preside your case, where your arguments are not being heard, where a judge calls you a narcissist in an open hearing, although you have not even said anything except, I plead not guilty. How can you trust a system like that? What kind of effect will that have on you psychologically, when you know that your whole environment is skewed against you and is only after a certain result and will not listen to you? This time, when you don't have a normal social contact, that will fundamentally, profoundly destabilize a person, and it will show precisely the effects that we have observed and measured medically, and clearly fulfilled all the criteria that we would see in a person that is exposed to psychological torture. It is psychological torture. So, I have written these letters to all these states. I've received responses from all of them. The UK, I told you, it took them 5 months to write a one-page letter. Sweden responded already in July, basically saying, "Oh, you're criticizing our judicial institutions, but we are the government, so the judiciary is independent. We can't really look at this." And clearly, I've written back to them and said, "Well, my counterpart is the Minister of Foreign Affairs in all the UN member countries, but I'm asking you, please, to render you good services and transmit my concerns to the judiciary and ask them to respond to my questions." And I asked 50 questions for 50 perceived due process violations in the Swedish proceedings, including very grave conflict of interests and manipulation of evidence and all these. And I do speak Swedish. I have one of my citizenships is Swedish, so I could read the original documents. I was very concerned to see how these proceedings have been conducted, and I asked specific questions to ask them to explain the lawfulness of each of these points. And Sweden wrote a letter that I just received on the 11th of November, basically saying we have no further observations. To me, if you're confronting a state and they have an explanation of the lawfulness of their conduct, they will be eager to explain it to you. If they say they can't explain it, it probably confirms the perception of unlawfulness. I received a response from the US saying, oh, Mr. Assange has never been in our jurisdiction, so in any case we're not responsible for anything. And by the way, we can't really agree with your assessment that this type of mobbing that I described in my report, that this could amount to torture and ill treatment. So I answer to the US in this regard the legal aspects, why I consider them to be responsible and certainly jointly responsible for the treatment of Mr. Assange, and clearly the US proceedings being the motor behind all of this, where the responsibilities are. And I also pointed out why exactly I am of the opinion that Mr. Assange would be exposed to cruel, inhuman or degrading treatment in the US if ever extradited there. And the precedents set by the various proceedings at the so-called Espionage Court in East Virginia. I will not go into the details now. Ecuador sent me a very long letter accusing Mr. Assange of all kinds of things, of mainly relating to tidiness and dealing with the cats and so on. I never expect that I would have to deal with cats and skateboards in my mandate, and I also think that this really is not worthy of discussion. We are talking about someone who has exposed information and evidence for serious government misconduct. That's what needs to be investigated. If he has committed any offences, let's investigate them, but how you deal with your cat and your skateboard in an embassy really is none of our business, and it really deflects attention. And this is, I think, the point here. Everyone focuses on Mr. Assange and his cat and his skateboard, but no one focuses on the one putting the spotlight on him. The elephant in the room is not Mr. Assange, and it's not his personality or even WikiLeaks. The elephant in the room is the information he has exposed, and that no one wants to investigate because it leads very high up, probably, in many of those countries. So, in order not to get too long, I have obviously engaged again with all of these states. I have written follow-up letters, asked the Swedish, as I said, these follow-up questions. I've also received from various reliable sources information that the health condition of Mr. Assange is deteriorating, as is to be expected in these conditions, this constant arbitrariness and the isolation he's exposed to. I waited to see what will happen once his sentence was served for the bail violation. And now, obviously, he's being kept indefinitely in relation to the extradition request to the US, and under conditions that are profoundly inhumane. So I sent a follow-up letter to the UK at the end of October, and you've probably all seen my press release on the 1st of November that I'm seriously concerned for his life. I don't think this is being taken seriously enough. I don't think anyone understands how intense the pressure is when someone is isolated and exposed to this constant arbitrariness, and how rapidly someone's state of health can deteriorate. Both medical experts have explained to me that psychological torture is not torture light, and I know that from experience of my own profession of talking to torture victims for 20 years. Psychological torture aims directly at a person's personality, at their emotional and in their identity, and it has physical consequences, and it can very quickly go into a downward spiral where these consequences will be irreversible on the nervous system, on the cardiovascular system. It needs to be taken seriously. I called on the British government to release Mr. Assange without delay, and to certainly alleviate the conditions of his detention. If he cannot be released, to a situation where we can lead a normal life and regain his health, and certainly gets all the facilities he needs to prepare his defence. I will be happy to respond to any more specific questions you have, but I think I will stop here so not to take too much time. Thank you very much.
Thanks very much. It was an incredibly moving presentation. Look at Assange and WikiLeaks publishing so many documents on international intelligence agencies, global military conflicts, government surveillance tools, the emails of government officials, global corporations, bankers and arms dealers. He certainly has pulled back the curtain on the brutality and corruption of many governments and the secret collusion of those in power with private interests, how we're spied upon, how wars and deaths are organised, perpetrated and profited from, and how many crimes are carried out in our name by those in power. Through his journalistic work, I think he probably was closer to the bone than he even knew, and he's paying the price for it. Robert Carr comes to us from Australia, which is also the birthplace and home of Julian Assange. Robert, or Bob as he's known, was born in Sydney and attended the University of New South Wales. Before entering politics, he worked as a journalist. He entered the New South Wales Legislative Assembly in 1983 and the following year became a cabinet minister. By 1995 he was the Premier of New South Wales, an office he held for 10 years as the leader of the Australian Labour Party. He later entered federal politics as a New South Wales Senator and served as Foreign Minister under Prime Ministers Julia Gillard and Kevin Rudd. He retired from politics in 2013 but has maintained a presence in Australian public life, publishing a memoir, Run for Your Life, in July 2018. Since Julian Assange was charged by the US, Bob Carr has become increasingly vocal about the case, and his interventions in Australian media have accompanied statements from other prominent Australian politicians calling for action from the Australian government to safeguard Assange's rights. His contribution and his stand is very significant. I welcome Bob.
Thank you very much. It's a great honour to be able to talk to you and to say, first of all, before anything else, that the present condition of Julian Assange needs to be addressed. I think it's as brutally simple as this. If he were, God prevent, to die in prison, then the finger will be pointed with total justification at the political leaders who've allowed him to be, according to my understanding, in maximum security, conditions of maximum security, with intermittent access to his legal representatives. And I'm also told from someone who was able, after a lot of trouble, to get permission to visit him recently, that he is denied access to the papers he wants to prepare his defence. This can only add to the stress that has already been described. And I want to send a message to my friends in London to think carefully about holding a political prisoner like this in maximum security, and think of how you might be held responsible should the worst happen. So that's the first thing I want to make, but I take this opportunity to raise the matter of the precedent. I've given some thought to the precedent involved here in America's interterritorial reach. And someone said in The Guardian, one of the former collaborators of Julian Assange, John Shipton, he said, acknowledging all his disagreements with Julian Assange, he was quick to say this, and I quote from The Guardian of May 26 this year. he was quick to say, quote, imagine the precedents if the Trump administration gets away with this. Israel and India have extensive nuclear weapons programs, each protected by ferocious domestic official secrets acts. Think of the outcry if the Netanyahu or Modi governments attempted to extradite a British or US journalist to face life in jail for writing true things about their nuclear arsenals. And I can think of some precedents here that could involve an Australian journalist. Imagine an Australian journalist working with a group of Papuans somewhere in the UK, and he or she puts on a website material from the Indonesian government secrets. It's an exact analogy with the Assange case, were the Indonesian government, in such a working example, to attempt to extradite this Australian journalist from the UK to have him or her face trial in Jakarta. How comfortable would Australians be at that? Or in the case of an Australian journalist with something to say from official secrets about the way the government of Myanmar was dealing with the Rohingya people. Imagine an Australian in the UK with the opportunity to post secrets from the government of Myanmar. And imagine again the analogy, as far as I can see, is absolutely precise. The government in Myanmar reached out to get that Australian extradited from the UK, put on trial in Myanmar for breaching that country's National Secrets Act. And think of an Australian, for example, with secrets from the Indian government about their behaviour in Kashmir, or from the government of Beijing about their policies in Xinjiang province in respect to the Uyghurs. An Australian could post this material, and then, given the precedent that would be established by what's happening with Julian Assange and the American attempt to extradite him, be the subject, providing the extradition treaty existed between the UK and these governments, of a bid to bring him or her from the UK to face trial in their countries. So the extraterritorial reach, using of all things the Espionage Act, which has got a very dubious history in the United States, used to imprison, I understand in its history, critics of America's involvement in World War I, is very disturbing. But it's not unique to the United States. And as Russ Bridger in The Guardian said, he used the adjective ferocious, describing the comparable legislation that the countries he nominated would be in possession of, capable of them using should this Assange precedent be entrenched. So the first thing that concerns me is the precedent about extraterritorial reach. The second point is to insist on the public's right to know. Could anyone argue that we are poorer as citizens because we know the material that's just been described about bankers and arms dealers, about the brutality of democratic governments, about corruption, about collusion with corporations? Would anyone argue that we're poorer because our right to know has been fulfilled by the material that Mr. Assange has made public? And more particularly, do we have a right to know that during the Iraq War, a war embarked on outside international law, it had no approval in a resolution of the Security Council? Famously, the US and the UK failed to secure such a resolution of the Security Council. This was not a war that was able to invoke the principle of a responsibility to protect or a Security Council endorsement. So in a war conducted outside the realm of international law, an atrocity was committed. Did we have a right to know? that American service people in their helicopter were able to take the lives down below on the ground, recorded on film, on video, of Iraqi civilians. I think we did have a right to know. I think we're better, we're healthier because we know that happened. And I would have thought the better course for the authorities in the United States, rather in the spirit of Barack Obama pardoning Chelsea Manning, would be for the US to quietly drop this extradition. Especially with the third point I want to make. And I'm drawing on material from the Australian Department of Defence, secured on freedom of information. This deals with the question of whether lives were lost as a result of the airing of these secrets. And we're lucky to have a swathe of material officially supplied with various redactions from the then Australian Defence Minister, which released in 2010, which establishes that a task force in the Department of Defence charged with looking at whether there was any loss of life or even the prospect of a loss of life, any damage done to Australian service people and their Afghan collaborators as a result of the release of the Assange material, the WikiLeaks material. And the conclusion of the task force was that no Australian collaborators in the Afghan population were compromised. Let me quote. The task force concluded that the leaked documents were tactical level operational reports containing, quote, information that is now sufficiently aged that it poses minimal threat, unquote. The task force says it was, quote, unlikely, unquote, that Australian or allied forces would be directly endangered by the leaks. The leaked documents did not contain, quote, any significant details about operational incidents involving Australians beyond that already publicly released, unquote. The task force also investigated whether, quote, WikiLeaks published any information that could put Afghan nationals at risk of retribution for their work with Australian forces. Continuing to quote direct from Australian Defence Department documentation. The investigation found that no Afghans with whom Australians had worked were identifiable other than those who worked with Australians openly, such as officials or community figures, unquote. So this internal review completely undermines comments by some commentators in Australia that, and I quote, the disclosures risked endangering coalition troops and could bolster Taliban insurgent propaganda, unquote. This is a very, very important release of the work by the conclusions of a task force in the Australian Defence Department. It comprehensively rebuts the suggestion that lives were lost or even put at risk, the lives of Australian service personnel or the lives of their Afghan collaborators. And that reinforces the material that emerged during the Chelsea Manning trial when only one name was produced by the prosecutor, the American prosecutor, to make the point of damage as a result of these leaks, with the prosecutor, as I understand it, then having to retract because the release of that information didn't flow from WikiLeaks at all, but had been known, had been out there, known from another source entirely. So that's the second point I wanted to stress. The third point I wanted to stress, I should say, the fact that there is no proof of loss of life or even a threat of loss of life as a result of this release, the release of this material. I think something, I'm just talking about the political atmosphere in Australia, I think something the Australian government has got to think about very carefully is this, that should America win extradition and Julian Assange, an Australian citizen, be seen in television footage being escorted, perhaps with his arms in chains, across an airfield towards a US military aircraft, to be put on trial in the US, parts of the trial or all of it being held in secret, there will be a serious political backlash in this country. And if I were the Australian Foreign Minister, I'd be saying to my American counterpart firmly, but in a friendly spirit, we're a very strong ally of the United States. We prove that again and again and again. But my strong advice is that unless you want to risk a backlash in Australian public opinion against the behaviour of America, you should quietly drop this attempt to extradite an Australian, especially given that this would establish a very disturbing precedent. It would set back the right of the public to know about the behaviour of their governments, and especially as we Australians have confirmed that there was no loss of life and no lives even put at risk as a result of the WikiLeaks exposure. On the bottom line, freedom of the press is more important than punishing Assange. Just two things stand out as far as I'm concerned. One, he is an Australian, and the Australian government should intervene for his defence, and intervene strongly now to see that his prison conditions are alleviated. And I appeal to my British friends, really, you can do better than this. If British justice means something, it means getting this bloke out of maximum security and seeing that he's got full access to his lawyers and to his papers. He exposed, the second point that is important from an Australian perspective is that he exposed things that deserve to be exposed and reinforced our right to know. In that spirit, we should be intervening strongly, and I hope Australia does pretty soon, to see that this extradition is quietly dropped, but in the meantime, his prison conditions are rendered humane.
Thank you very much, Bob. That's a very strong contribution, and people should not underestimate the significance of what Bob is saying and the weight that he carries. And we in the European Parliament are extremely grateful, and there's people here from groups across the table, and it means a lot, and hopefully we can work together going forward to actually improve what's happening. Thank you very much.
Thank you.
We're going to go into a question and answer session, and obviously there'll be a time constraint, but we'll try and fit in as many as possible, hopefully all that want to ask questions. So I think it's always best to remember that it's more important to ask questions than to make statements. We have some you've had 3 powerful contributions, and you should be asking them the questions. I'm just going to, I was asked to invite Julian's dad, John, to come in first, and then there was 2 particular journalists, Anthony Belmarsh and Patrick Kamenke. Sorry if I didn't pronounce them properly. And we'll then ask some of the MEPs if they want to ask questions, and then we'll open it to the floor. Thank you very much.
Thank you very. Excuse me. Thank you very much. I just would like to point out a couple of things in the avalanche of procedural distortions that Julian's been subjected to. You may have seen on TV his last court appearance, where he had difficulty remembering his name and his birth date. He had, before appearing, had been strip searched and put in what the prisoners call a hot box. I don't know what that is yet, and consequently was very, very disturbed, and that built upon the basis of psychological stress that Nils Melzer elegantly described. The publications that we're all referring to were published in the UK and Europe. They're European publications. They're published in Der Spiegel and El Pais and The Guardian. This is a European matter, and the judicial kidnapping of a European publisher publishing in Europe with European staff and European corporations or publishers, the judicial kidnapping of that publisher is a profound concern for the states of Europe and the European Union. Next, the gifts that the publications gave us, or the WikiLeaks publications, just last few days in the Bolivian coup, we were able to look up the names of some of those involved in the coup and see the references in the cables to their involvement with other actors or with the United States. The appearance that I referred to in court just a few days ago, the Australian barristers, criminal law barristers who deal with Indigenous people, Philip Siegel, Greg Barnes, and 8 others, have said that they've never seen a defendant brought into court in that condition in 50 years of working in criminal law. Never seen a defendant brought into court in that condition to face charges, to face extradition in that condition, unable to remember his name. We must face this ceaseless prosecutorial persecution of Julian, and we must insist that it stops, and it stops straight away. With the collateral murder video, Kristen Hanifson, this is another aspect that you don't see of WikiLeaks. With the Kristen Hanifson, with the collateral murder video, Kristen Hanifson travelled to El Sadr city in Baghdad at risk of his life, negotiated to be able to speak to the nephews of the 2 journalists that were murdered. WikiLeaks, Julian and Kristen tried to give names to the dead. This is fundamental humanity. It's an aspect that we don't see of Julian and Kristen. They brought names to the slaughtered. I think, to see, somebody with that breadth and depth of humanity and determination to bring to us what facts that he can so that we can make appropriate decisions about our lives and see the dangers that lie before us or the opportunities and who are our friends and who we can cooperate with safely. And also to name the dead. Very important. Anyway, thank you very much.
Thanks very much, John. It doesn't need any comment. Right. We'll invite concise questions, starting with Anthony. Bellinger. Yeah.
Bonjour à tous. Je vais m'exprimer.
Good morning, ladies and gentlemen. My name is Anthony Bellinger. I'm Secretary General of the International Federation of Journalists. We're based here in Brussels. We're the largest international organisation. We represent 600,000 journalists around the world, and we're present in 146 countries in the world. Julian Assange, obviously we've had campaigns there, and we also support to those who are based in Australia, AEMA, the Media and Arts Alliance, 147 affiliates. Julian is also a member of the Australian affiliate organisation, so we've always considered him as a journalist. The Assange case for us is an attack on press freedom. It's also an attack on a violation of international law. It's a quite simple question that we ask ourselves. We ask the Commissioner for Human Rights here in Europe, our colleague Dunja Mijatovic, as someone we've worked with significantly when she was at the OSCE. We asked her whether the arrest of Julian Assange and a possible extradition to the US are in line with the European Convention on Human Rights. Journalists, as you know, can receive protection from Article 10, under Article 10 of the European Convention on Human Rights, and this is recognised. And it's been of information which has been shared, and it's when there's a public interest, that's how there's protection. When a journalist publishes something to benefit from this protection, that needs to be done in the public interest. Now, all Julian has done is to disseminate the truth, and dissemination of information, of documents in the public interest cannot be considered a crime if it's in the public interest, as I've said. So this affair raises for us a key question. Assange is an Australian citizen. He's not a US citizen. He's committed no crime in the US. He's disseminated confidential information, but that information has also been published by others, and Ms. Daly, you said that yourself. And that information hasn't been stolen. But even if it had been stolen, there's still a legitimate defence. There's been no crime committed. The only crime has been highlighting the crimes and atrocities of others, above all in Iraq and Afghanistan. Now, I'll conclude on this. We will continue this international struggle to support you, and we'll support all of you, MEPs, UN Special Rapporteur as well. I particularly appreciated the comments you were making on torture, and I think it's an angle that we need to use as well. We can support all of the human rights activists and activists for freedom of expression that I've met this morning and I've seen this morning. We continue our work, and we will be shoulder to shoulder with you to support freedom of expression, and also issues around Article 10 of the Universal Convention of European Convention on Human Rights. Thank you.
Patrick Kamenka. Yeah.
Oui, bonjour. Je vais aussi parler.
Yes, thank you. There's a few points that I wanted to add to what my colleague Anthony has said. I represent the French trade unions for journalists. With our Australian colleagues, we signed a letter in our most recent Congress in Tunis. Now, that letter supported the Julian Assange's case. Again, for us, Julian is a journalist. There's not even a question. The real issue we have today, as the panelists have said, this has become very urgent. We need to solve this issue very quickly and ensure that his health doesn't degrade any further. We also need to stop the extradition to the ESCO. That would be extremely serious. In our Congress, we voted unanimously on 2 motions, and I can read them to you.
Case to the UN Human Rights Council to call on the European Parliament and the Council of Europe to respect freedom of opinion. I
think based on these 2 motions, with the defence team and with those present here today, MEPs, national, international organisations, we are sparing no effort to try to remove Julian Assange from the inhumane conditions he's currently suffering in prison. I think, for me, he's a political prisoner. We need to be clear about this. We cannot, in the European Union, continue with this situation. We can't have this situation where the mainstream media just looks the other way. I think we have a struggle, a fight for freedom of expression. Anthony reminded us that Article 10 of the European Charter of Human Rights expressly says that everyone has freedom of expression. There's a general interest here which has primacy. Now, recently the European Parliament voted for a directive on whistleblowers. I think we need to use all the resources all resources available to us, and we need to protect him as if he were a whistleblower. With the European Defence Team, we need to see if this can be referred to the European Court of Justice, because this is focused on undermining democracy, and this is done for motives of defence. Now, the final point I wanted to mention is that in France, I think Julian Assange has a child. We, the French trade unions, think that we can speak to President Macron about this issue and to offer asylum to Julian Assange in France on the day that he's released, if he wishes that.
Thanks very much. Time will be of the essence. I'm going to invite expressions of interest to ask questions. We won't have any more time for statements, so anyone who wants to ask questions to the 3 panellists, we'll take a few questions together. So, yeah. Patrick, Matthew, okay, go ahead. Yeah. What's your name?
John Loughlin.
Right.
Thank you. My name is Patrick Breyer. I'm a member of the Pirate Party, and I'm greatly concerned that the online publication of information is treated differently from traditional paid journalism. I don't think that takes account of how of modern society and digital transformation. I have a couple of questions to Mr. Melzer. And first of all, I would like to thank all speakers for your work on this case. Mr. Melzer, first of all, you said that you called in a letter for the release of Julian Assange. On what basis? Secondly, as to his isolation in confinement, can you let us in on what the rules are on the jurisprudence on isolation? Is there a clear jurisprudence on that is being violated by the United Kingdom? And thirdly, if the UK court decide he should be extradited, can you explain us what are the legal avenues of recourse of appeal? Could this be brought to European courts before he will be extradited? Because I'm wondering whether it would make sense to deal with this in the Committee of Civil Liberties. I believe that we could make the UK government answer some of the questions they have refused to answer to you.
Right, we'll take questions from Matthew and John as well, and then we'll let the lads reply.
Okay, thank you very much. I'd just like to echo what you said. My name is Matthew Patton. I belong to the Brexit Party. I'm an MEP. I'd just like to echo your words. The panel speeches are excellent. I also want to say to John, as a father myself, I hope if ever my children ever got into trouble, I would speak as eloquently and work so hard, as passionately as you have. I found what you had to say in particular really, really striking this morning, so thank you for that. I just have a really simple question. It's been an eye-opener for me. I've learnt a lot. I want to know what you want us MEPs to do. I'm obviously a British MEP, so there are very particular issues in terms, I'm shocked by some of the comments that I've heard today. But I want to know what you want us to do so that we can do it. Thank you.
John. Thank you. My name is John Lockland. I work for 3 Dutch MEPs in the ECR group. I have 2 specific questions, one of them to David Greene, one to Nils Melzer. But I also wanted to respond to what Bob Carr said about the precedents which the Assange case will make. I've written extensively on international criminal justice, and I'm afraid that in books and so on, and in many articles, and I'm afraid that unfortunately all of the precedents that he fears have already been made, and indeed have been made quite a long time ago. And I hope I don't shock anybody here when I quote the names of some very unpopular people who, in my view, have been victims of the same injustice that Assange is. The precedent of extraterritoriality was set when General Pinochet was arrested in London on the warrant of a Spanish judge. The idea being that he should answer in Spain for crimes allegedly committed in Chile. The precedent of someone dying in prison was set when Slobodan Milosevic died in The Hague, a man whose country had been the victim of an illegal NATO attack in 1999 and who was subsequently exonerated by later rulings of the International Criminal Tribunal and of the International Court of Justice. And the precedent of political prosecutions was set by the Charles Taylor trial, which was a purely political set-up by the Americans. Charles Taylor, the former president of Liberia. So those are my comments about what Bob Carr said. Unfortunately, universal jurisdiction has led us for 20 years at least down a very dangerous alley, and Julian Assange is not the first victim of it, he's only the latest one. My questions to David Greene. My question to David Greene is very precise. The Espionage Act. Espionage is usually regarded as an activity carried out on behalf of another state. More recently, of course, you can also include industrial espionage. My question to you is, does the Espionage Act limit activities to those carried out on behalf of another state, or does it imply that they are only activities carried out on behalf of another state? And is the allegation that Assange acted on behalf of another state contained anywhere in the indictments? And my question to Nils Melzer is, which British minister replied to you when you said you wrote to the British government? Was it perhaps Rory Stewart, the Minister of Prisons, who now presents himself as a great liberal and who is going to run for Mayor of London?
Sorry, my mic wasn't on. I said thanks very much for the questions, and we'll ask the 3 lads to respond as they see fit. We'll start with David.
Yes, I can start. Yes, so the Espionage Act, in its language, does not require that anyone charged under it have acted on behalf of another state. It merely says that they've acted with knowledge that their actions could harm the United States or work to the advantage of another country. And there's no allegation in the indictment against Assange that he was working on behalf of another state. The allegation is consistent with the language of the Espionage Act, that he had knowledge that this could be to the detriment of the United States.
Yes, thank you very much. Yeah, there were a couple of questions. On what basis did I ask for the release? Well, First of all, I think the Working Group on Arbitrary Detention already a few years ago decided and concluded that Mr. Assange was being detained arbitrarily at the Ecuadorian embassy, and I share that position. And I also am of the position that his imprisonment by the UK from the outset, and in relation to the bail violation, the so-called bail violation, is arbitrary. Because let's remember that the only thing that caused Mr. Assange to violate the bail condition was that he was seeking, and he also received, asylum by another UN member state. That is not a crime. That is, in my view, certainly even a justification for the bail violation, or at least such a strong mitigating circumstance that imprisonment is simply a disproportionate sanction for an offence, if at all it is an offence. So, but then let's also, that is the imprisonment for the bail violation, which he has already completed. So now his deprivation of liberty is based only on a possible risk of absconding during the extradition proceedings by the US. I don't think that if you want to prevent his escape, you need to put him in a high security prison in Belmarsh, where he doesn't have access to any social life, any legal documents. I think it is very important that we look at what's the purpose of detention. Deprivation of liberty is arbitrary if there is no legal basis and it's not necessary and proportionate for the purpose that it serves. I don't think there is any necessity and proportionality in the current conditions of detention that are being imposed on Mr. Assange, even looking also at the extradition proceeding, which in my way cannot be possibly lead to a lawful extradition given the purposes and the reasons behind that extradition. So that's the whole the legalities around it, but then also because of his current state of health, which is so becoming so critical, that I think it is all the more important that that we're looking at his conditions of life now need to be shaped in a way that the priority is given to his health being protected and his procedural rights being protected. I don't think this is possible in the current setting, and so I have asked the UK government to release him immediately, and to, if necessary, if the extradition proceeding is to go on, although I don't think there is any prospect of a lawful resolution of that in favour of an extradition, if they still want to stick to that proceeding, then his presence has to be secured in a different way, maybe house arrest or something like this. There are other possibilities to do that. On isolation, I think what we have to be careful when we use the technical term of solitary confinement. It's somewhere between, if someone is being kept in solitary confinement, that means in isolation for more than 22 hours, up to 23 hours, certainly a day, then that would count as a solitary confinement. If that lasts more than 14 days, then we would say it's prolonged and can amount to cruel, inhuman and degrading treatment. And if there is a kind of coercive purpose, then it could also amount to torture. I think we don't need to necessarily go into how many hours exactly, is it 23, is it 22? I think in his case, we simply have to face the reality of him being isolated from anything close to a normal life and social exchange with other inmates, that even high security detainees in that prison have that possibility, but he doesn't. The way he is being coerced and confined and isolated and surveilled in accumulation certainly amounts, in my view, to cruel, inhuman and degrading treatment. It is not necessary, there is no legal basis for this, and it's not proportionate to any lawful purpose of keeping him anywhere. The extradition case, is there a possibility to go to perhaps Strasbourg or other international institutions beforehand? Where there might be. You could take the basis, for example, of torture and cruel, inhuman or degrading treatment. You don't have to wait for the decision on extradition for that. You can take that to Strasbourg, you can take it to the Committee Against Torture. These are questions, though, about procedural tactics. And this is not, I'm not his defense counsel, and I don't want to make any recommendations in that regard. I think he has a legal team that will determine what's in his best interest, in the best interest of his case. But certainly there are procedural possibilities to take something to international instances before. And obviously my mandate is one of those international mechanisms, and I'm certainly very engaged in that case for the reasons that I explained. The question, well, what can we do, or what can members of parliament do in their own country? Well, it is to insist on the rule of law. To insist, just insist on the rule of law. This man's procedural rights have been violated for 10 years by all involved states in every jurisdiction and in every step of the procedures. I'm not going to recount them here. You can read my letters. They're all public that I've sent to these countries. It is shocking to see how that's possible. And when I ask, as a UN official, to ask these states to explain to me how they think this is lawful in the light of their human rights obligations, they just respond, we have no further comments. How can we maintain a rule of law society if I can't even in my function engage with two European states, Sweden and UK, on their respect for rule of law in an extradition and a criminal proceeding? If they don't even respond to me, well, how far have we sunk, I would say? Which UK minister has responded? Well, my counterpart is always the serving Minister of Foreign Affairs, the Foreign Secretary. It was Jeremy Hunt at the time. My exchange with him was that, well, I sent an official letter to him, and then he responded with a tweet saying, oh, this is not right. The Special Rapporteur should not interfere with the UK judicial system. But he forgot that just 2 weeks before, his ministry invited me to visit Julian Assange, and actually in my function as the Special Rapporteur on torture, and obviously he knew and would have to expect that I would report on torture. So, and in his tweet he also pointed out that Mr. Assange was free to leave the embassy at any time, and my response was that he was about as free to leave as a person sitting on a rubber boat in a shark pool. And I think that is really what happened in this case. I'm not usually engaging in this type of conversation. I stick to diplomatic procedures, but I think it shows if a foreign secretary, the only way he responds in 5 months is to send a tweet, it means he's not taking my mandate seriously. He is not taking my report seriously. They're not investigating my observations. And that, to me, is of utmost concern for the international community when states do no longer engage with the institutions they have created to protect human rights. Final thing on, well, so the response was through the permanent mission. Sorry, I do want you asked who responded. It was the Foreign Secretary through the permanent mission to the UN in Geneva of the UK. Final thing about universal jurisdiction, Milosevic, Taylor, Pinochet. I think there is one very important difference here. All of these persons have been accused of crimes for which there is international universal jurisdiction. Human rights violations, war crimes, crimes against humanity. Mr. Assange is not accused of any of those. He has exposed those. But these people that are responsible for the crimes he has exposed have not been prosecuted. And there is universal jurisdiction for those crimes, but there is not for investigative journalism. Investigative journalism is not a crime. Thank you.
Bob? Is Bob still on the line? Yeah, is Bob, if you'd like to respond to any of the questions asked. Sorry, we can't hear you there yet, Bob. What's the problem, Oisin or Fionn?
What's that like? Can you hear me now?
Yeah, that's perfect. Thank you. Yes, perfect.
Yeah, I'll just make one very quick comment, and that is that I think the issue that faces all of us, in fact, right now, is to separate next week, to separate from the broader issues of the American extradition, his alleged offences, the defence that he has got to American allegations, to just separate that for the moment and see if we can get pressure to have his prison conditions alleviated, to see that he's got access to his lawyers, unambiguous access to his lawyers, he's got unimpeded access to whatever of his own papers he needs to have to prepare his defence, But as a political prisoner, there's no physical threat to anyone. He is relieved of the burden of maximum security detention, that he is detained in minimum security. And surely there is the opportunity in your parliament to have people with contacts in the British government pay attention to this, first and foremost, and most immediately, to relieve the inhumane conditions that apply to him right now. Thank you.
Thank you very much, Bob. Okay, we'll have to wrap up. We're running out of time. Do you want? Okay, well, we'll invite a few more questions, and then we'll get Clare Daly to wrap it up. Is there anyone else for a question? Okay. So, what's your name?
Anastasia Politi. Je suis artiste de théâtre.
I'm a theatre artiste, and I represent the Ariel company in Paris, and I'm also a Syriza grassroots militant, Syriza, and I'm sorry that the Syriza members of the European Parliament are not here today. I just wanted to respond to this idea that President Macron be asked to intervene. I'm afraid that would be a vain effort, because Julian Assange is really fighting against the cynicism. His gesture was a humanistic one, and at the present time cynicism is the prevailing wisdom in France and elsewhere. But perhaps you're better placed than I am, and perhaps there is a window of opportunity vis-à-vis President Macron. If the miracle came to pass, if because of a mobilisation of society and certain institutions, such as you, Mr. Melzer, I do thank you and everyone here today for your effort. What faces Julian Assange? How could he be protected afterwards? I'm optimistic, and once that miracle materialises, once he's freed, what would happen to him then? Would he then become a target? We know that there are mafia interests, there are commercial interests, there are arms dealers, there is drug trafficking. And can I say that parenthetically, the funders of the election campaign in Greece, the party which won those elections recently, is someone who is accused of drug trafficking. And my question then is, how will Julian Assange be protected? Will he acquire a different nationality? If so, which one? Could he be recruited, hired as a political counsellor by advisor by members of Parliament, this Parliament, in order to have links with an institution which is seeking to protect him? What will become of Julian Assange afterwards?
Thank you very much. Anyone else?
I'm Zlatina Ruseva. I'm the artistic director of International Documentary Festival here in Brussels, which was created to support the SDGs by the artists. And one of the main topics of our festival is the human rights. We are organizing a big event with a screening of the film Hacking Justice, which film Assange during 5 years when he was in the embassy. And we invited also the lawyer, Baltasar Garzón, just who could maybe speak and explain what is the possibilities, what is the law situation, because there is really a lot of violation of international laws. And human rights. So maybe he could answer some of the questions which are here now. So, and you are invited to come to the event that will happen the 20th of November in the Palais of Beaux-Arts. So there will be, we try to make a big event trying to push the journalists to react, because it is impossible that in the main media there is nothing about this. And I think the Julian Assange case is a case of the civil society and the democracy, and it is important that the media and the journalists defend themselves. I'm coming from a totalitarian country, Bulgaria. I left because of just this attack against the freedom of speech, and I never imagined that here in Western Europe I have to defend again the right to speech, to expression, and yes, human rights. Thank you. Sorry, it wasn't a question.
Thank you. There was one other person there with their hand up.
Oui, bonjour. En fait,
Good morning. I just wanted to ask for your support. I'm a citizen. I'm part of the Assange committee trying to fight for his freedom. I would have seen he's having difficulty in speaking to the press. There's not much interest, and it's good to hear that Mr. Belmarsh has talked about it. We're sending to a range of different organisations. We've not had many responses from the press. So listening to Mr. Belmarsh today, that actually gives us hope. Now, I wanted to say that the majority of the people who are in the committee are volunteers, peace activists, etc., people from all different walks of life. But we are struggling to make a strong bond with other people's yourselves. The European Parliament is a world apart. How can we do that to be more effective? You know, we're following the Assange case on a daily basis, and we want more help and more interaction with different politicians and different civil society groups. Now, is there someone here in the room today that we can speak to, who's perhaps based in Brussels, that can be a point of contact for us, so that we can think about the future and continue to fight for Julian's freedom?
Thank you very much. We're being told we're going to lose our translators very quickly, so I'm going to ask Clare Daly to sum up. Thank you very much.
I'll be as brief as I can, and for those who don't speak English, you'll probably lose me a little bit the way through. I'm very sorry about that. Look, I think on behalf of ourselves, we'd first and foremost like to thank the speakers who've been with us today. Bob in Australia, who's had to interfere with his body clock and the time differences to be with us, not just today but yesterday as well in the trial run. I think his input was absolutely powerful. David, who travelled all the way from the United States to be here and impart his contribution, and Nils as well for his very, very powerful contributions. We certainly feel that we were privileged to experience their input, and I suppose I speak for all of you when I say their contribution, and particularly the contribution of John Shipton, I think also has emboldened and encouraged all of us to redouble our efforts in many of the campaigns that many of us are already involved in. And I think you heard that from the other speakers, the event that's taking place in Brussels next week, the weekly activity that goes on here, the activity that's going on in countries all over the globe. And I think we should register to those who are listening in that those of you who have taken the time to come and join us this morning here represent hundreds of thousands of people in your various trade union organisations, in your political organisations. We've had representatives here probably from most of the European member states. We're absolutely grateful to our MEP colleagues, particularly those who've joined us from outside of our political grouping. I think practically all of the political groupings and a number of representatives from the unaligned groupings have attended here today, and that gives us great confidence, because to go back to the question that Matthew asked, what do they want, or what do we want you to do? Well, I suppose what we want the MEPs to do is to use our position as much as possible. The extradition trial starts in February. Worryingly, it's been held in Belmarsh instead of open in Westminster Court. Very, very unusual, in a secluded small venue where the family are even going to have difficulty in attending. We want an international presence of international observers to go and attend that extradition hearing from February. We want all of us to use our position here to highlight the violation that's presently taking place of Julian's human rights in terms of the prison conditions and all of the other issues about his legal documents being taken, confidential personal information being handed over by Ecuador, digital devices of his personal medics were interfered with. All of the issues that have violated his human rights, we want them raised, because this, I suppose what we've all learned more than anything else is, while it is about the life of one man, I think none of us could but have been struck by the seriousness of the situation now for Julian Assange's life. And important as that is, and it is incredibly important, the implications for the public's right to know and freedom of the press go way, way beyond this. And that's why we're here. So I think I speak for all of us. I'd like to encourage you to join us. Some of us will have to go for a vote, but there is some light refreshments which we'll be having now. People can exchange information, share the experiences of the different activities that are being organised over the next while. There is material, postcards to the British Home Secretary that people can collect and post out. We've even kept it blank, given that the elections are on. It doesn't matter who wins, the appropriate person will get the postcard and all the rest of it. But look, I just want to thank you all and look forward to working with you in the weeks and months ahead.